Hines Bites, your Strata update, with Frank Higginson from Hines Legal.
Today we're going to talk about terminating management rights agreements. Leaving aside disputes with developers about building defects, these are the biggest fights you can have in a body corporate in Queensland. And up until recent times, there's been a fairly well-worn path that they follow. And for the benefit of everyone, I'll just explain that briefly. The first is the body corporate issues a remedial action or breach notice. So that's saying to the manager, you're not doing your job, you're required to do your job, and here's a period of time to do your job. The manager either then complies with that notice or argues the validity of some or all of it. After that, the body corporate either accepts that the manager's done what they have to do, or the body corporate calls an EGM to seek to terminate the agreements because of the manager's failure to do what they're required to do. Traditionally, what the manager then does is lodge an application in QCAT to prevent the body corporate from acting on that termination, assuming it's approved, until the validity of the notice itself has been argued in front of a member of QCAT. So that's where they have been going for time immemorial. Hundreds of thousands of dollars, years of disputes, all that sort of stuff. In recent times, there's been two different approaches taken by managers to a remedial action notice. So when we get to that period or that piece of the puzzle, which is termination, where the body corporate either resolves to terminate the agreement or not, if the body corporate resolves to terminate the agreement and the manager hasn't commenced a proceeding to contest the validity of that termination, that can be claimed by the manager to be a repudiation by the body corporate of that management rights agreement. And so repudiation from a contractual perspective is when one party to a contract says to the other, I'm not going to be bound by it anymore, and I'm bringing it to an end. So if a body corporate terminates an agreement in circumstances where it's not entitled to, that could be, and has been, interpreted as a repudiation of that agreement on the part of the body corporate. So that's where the body corporate's saying to the manager, it's over. What managers can do, rather than contest the validity of that termination to keep the agreement on foot, they can say to the body corporate, well, you've terminated that agreement unlawfully, and we're going to sue you for damages. So that's happened twice in recent years, which is a new approach to these things, which I suppose is the manager saying we don't want to be here either, and we'll roll the dice this way. In the first instance, the body corporate won in terms of the termination was valid, but in the second one, they didn't. And what that exposed that body corporate to was damages of more than $300,000. So from a body corporate perspective, this opens effectively a new risk to body corporates that seek to terminate management rights agreements, because the downside, if the manager goes that keep the agreement on foot path, is just costs. You pay your costs, and if you lose, you might pay some of the managers. For the repudiation one, you get to pay your own costs, you get to pay some of the managers, and if you've terminated the agreement unlawfully, you get to pay damages for the value of that agreement. So yet again, it just proves going down that termination path is a really, really important decision at the start, before you even start down there, as to understanding what risks you're exposed to. If you need help, let us know.